Mehairi and is being held by way of video conference. The claimant is represented by Abdul Hakim bin Hirz advocates and legal consultants. Lead counsel is Mashoud Iqbal. The defendants are represented by El Tamimi and Company. Lead counsel is Patrick Delamalone.
Thank you. You may proceed.
Good morning, Your Honor. My name is Mashoud Iqbal. I'm the counsel for the claimants in this matter. Just by way of housekeeping, if I may please confirm whether or not you are in receipt of a bundle that is prepared by those instructing me. It goes to a total of 86 pages.
Yes.
And also, just to make the best use of my time, can I assume that you are familiar with the facts of this claim so that I can proceed down straight to the issues?
Yes.
I'm very grateful for that. Thank you. Now, as I said that I want to make best use of my time, if I may please refer to the bundle at page number 83, please.
Okay.
That is where those instructing me have attached a document which is captioned as Case Management Order, and therein number of directions have been proposed. But before I, in fact, come to those, in the bundle, we have at page number 67, where we have a list of issues.
Yes.
Here, at page number 68, you can see just in the middle of the page, list of issues, and then you can see a subheading, preliminary issues. So there are two preliminary issues, and regrettably, both parties disagree on these two preliminary issues. The first preliminary issue is about the claimant's application for strikeout of certain parts of the defendant's defense, and also in the alternative, an application for an immediate judgment. Both parties disagree as to when the hearing should be listed for this particular application. The second disagreement between the parties is about the preliminary issue number 2, that is about whether or not this particular claim, 059, should be consolidated with a different Part 8 claim, which is 024. To keep the matter straight and simple, my focus shall be on the first preliminary point, and I would leave the second preliminary point towards the end of my submissions.
Okay.
So we submit, number 1, that the application for strikeout and immediate judgment was filed on 17th of November 2020. The strikeout application, which is required to be made under RDC 3.4, it requires a notice of 3 days, and the immediate judgment application requires a notice of 7 days, at least. However, in this case, the claimants gave 12 days notice to the defendants, and moreover, the skeleton arguments in support of such applications as a matter of good practice are exchanged around 24 to 48 hours in advance of the hearing, but we, on behalf of the claimants, disclosed our complete skeleton arguments 12 days in advance of 30th, which is today. It was our position that the application for immediate judgment / strikeout should be heard either before the case management conference or at least at the same time as the case management conference, so that depending on the result of the application, further case management directions could be issued and the issues in this case could be narrowed down. Now, again, retaining my focus on page number 68, please. If I can make a reference to paragraph number 3, please.
Mm-hmm.
In that paragraph, we have Roman numeral 1, that is to pay the claimant the monthly fixed fees of 40,000 AED starting from February 2020. We submit that if the application for strikeout / summary judgment is to be successful, then this Roman numeral 1 simply goes away, and similarly Roman numeral 3 shall also go away. And if you look at paragraph number 4, the recital of paragraph 4 is, if the defendants are in material breach of their contractual obligations. Our position is that if the application for strikeout / immediate judgment is successful, then at least, and we really say at least, 80% of the defendant's defense shall be wiped out. And that is why there would be no need for the first recital in paragraph number 4. Moving further on page number 69, and if I may make a reference to paragraphs 9, 10, 11, and 12, we say, if the application for strikeout / immediate judgment is successful, then there shall be no need for paragraph 9, because what we are seeking in paragraph 9 in terms of an issue, that would have already been decided by way of an immediate judgment for the claimants. And the same goes for number 10, number 11, number 12. Now, Your Honor, at the same time, with your leave, if I can make, please, a quick reference to the particulars of claim that we can see at starting at page number 5, please. And in that, if I can make a reference to page number 22 of the bundle, please.
Okay.
I'm grateful, Your Honor. Your Honor can see at paragraph number 46 that the claimant's claim for breach of contract has 2 limbs. Limb number 1 is about breach of contract by Sunset Rack, and there are 6 causes that are listed from paragraphs 47.1 to 47.6.
Mm-hmm.
And similarly, the second limb of the claimant's breach of contract claim can be seen at paragraph number 48. That is against Sunset BVI, the second defendant. And the cause of action has been listed in paragraphs 48.1 to 48.3. we say if the application for strikeout / summary judgment is successful, then the claimant shall be asking for immediate judgment to be entered in accordance with paragraphs 47.1, 47.2, 47.3, and 47.4. Similarly, and potentially, immediate judgment application, if successful, an immediate judgment can also be entered in respect of paragraph 48.1. So if, as we say, that our application for immediate judgment is successful, then all that we shall be left with in this particular claim shall be the cause of action in paragraph 48.2, 48.3, and coming back to penultimate page 47.5 and 47.6. So we say that quite comfortably, if the application for immediate judgment is successful, around 80% of the defense shall have been gone. Therefore, we say that the case management directions can and should only be issued once the outcome of the application, that is the application for strikeout / summary judgment, is known by both parties. Because alternatively, Your Honor, if this court gives directions today and lists down the issues and also set down the timetable for preparation of a number of steps, for example, disclosure, for example, inspection following disclosure, for example, preparation of witness statements, and those witness statements will obviously have to cover everything in the round, including everything that is pleaded in paragraph 47 and 48 of the particulars of claim. So we say that if the parties are put to that expense of preparing the case in the round, and let's say 2 weeks from today, the application for immediate judgment and strikeout is listed for a hearing and successful, then the great bulk of the directions / the issues that this court may put today shall become otiose. They will have no use. So in that event, there shall be, or there may be at least, putting it in mild terms, there may be a need for another case management conference hearing. That certainly would not be in the interest of overriding objective, which requires both parties to cooperate with each other, which requires the court to deal with the issues by putting the parties on equal footing, bearing in mind the proportionality of costs, bearing in mind the importance of the case, and some other factors. So we first of all asked the court to list the application for summary judgment, immediate judgment / strikeout to be heard along the CMC on the same date, because we were of the view that this application cannot and should not take more than 90 minutes, or if one has to really stretch it beyond proportion, then it cannot exceed 2 hours at the maximum. And the response that we received from the registry was, and perhaps maybe for pragmatic reasons, that the consent of the defendants should be obtained, or perhaps the defendants should be invited, if they agree, for the application to be heard at the same time at CMC. The defendants opposed the proposal on the basis, as I understand from my instructions, that the application in question is going to be a heavy application requiring more than 2 hours of time. We certainly disagree with that, as I've already said, and I'm not going to repeat what I've said unless I can be of any assistance to Your Honor. So we say that if the defendants had cooperated with us today, then there would have been every possibility that we could have streamlined the issues, or perhaps we could have narrowed down the issues, and also we could have narrowed down the directions, turning this claim into a simple, straightforward claim. Regrettably, that's not the case. So what we say today is that unless and until the application for summary judgment, immediate judgment / strikeout is decided in advance, any directions and any issues that this court may set may not long very last, and perhaps in due course we may need to have another CMC, and we must avoid that at any cost. Now, I'm very grateful to Your Honor that you have very patiently listened to me, and unless I can be of any further assistance to Your Honor on this first preliminary issue, I have nothing else to submit. But in due course, I will come back to the remaining list of issues / directions.
Thank you. Mr. Patrick?
Yes, thank you, Judge. First of all, I think it's surprising for us to have this suggestion being made today that there's an application before you of this kind, because even the document is not before this court that is being relied upon. The position is that that immediate judgment strikeout application was filed on the 17th of November, served on the 18th of November. It is patently a heavy application, and under the rules, our response is due on the 16th of December, and then the claimant's reply will be due on the 30th of December. And then it's just simply a question of obtaining a hearing date for that application. That could be accommodated in January, and there's no substantial overlap with the directions, the procedural directions in the proceedings themselves, which are fully pleaded. And there would be an overlap in January. The only matters that are directed in January are the standard production documents and the beginning of the specific disclosure, if any. But it's telling that actually the claimant has indicated already in its case management information that it does not intend to produce any more documents. And the position from our side is that we believe this very late and distraction of course, it is our position that immediate judgment. I know that you cannot take a view on that today, but just so that you know, for the record, it is our position that there's absolutely no reality in the application to strike out portions of our defence. If the court has had an opportunity to review the defence, it is a meticulously and carefully pleaded defence on all of the issues that are joined, and there's simply no reality. This is a sideshow, and I'm afraid it's typical of the confusion and chaos and lack of respect for the rules that has characterized every single engagement by the defendants in this case, and indeed in the other proceedings. And it is time, in our respectful submission, to place some order on the proceedings. We now have a fully pleaded Part 7 case in which the defendant, the claimant, as the defendant in the other proceedings, has brought. It's worth remembering, and of course it's relevant to the consolidation that I'll be addressing you on presently, that these proceedings are between different parties based upon different contracts, seeking different remedies. And one of them is a Part 8 proceeding, and the other is a Part 7 proceeding. And all of this comes at a very culpably late type of rearguard action, creating more confusion and more chaos. And it is time, in our respectful submission, to simply provide for straightforward directions in accordance with the rules. In respect of the immediate judgment application, we believe that the correct and appropriate course, in accordance with the overriding objective, is to allow the rules to take their course, direct a hearing of that in January, and then concurrently the main directions under the case management directions should proceed as set out in the draft order. And we see no reason why the immediate judgment application should delay matters. If the immediate judgment application is successful in any way, it's also the case, of course, that it won't succeed in striking out the entire case. The position of the parties, as indicated, is that further documents are not going to be produced. And the witness evidence, when it comes to that time, can adapt to any adjustment in the pleadings that is necessary. But as matters now are, this case is fully pleaded, and therefore we respectfully submit it should just, the court should direct matters to proceed. I'd like to say something about consolidation, but again, probably it's best that we deal with that later. I do want to say also that the suggestion that we didn't cooperate in any way with the claimant is not correct. In fact, the correspondence that the claimant had with the registry was not copied to us at the time, and the suggestion that there could have been a hearing of the strikeout application today is also incorrect, because even if it were a light application, the proceedings were, that application was filed on the 17th of November, served on the 18th of November, and even under the ordinary rules couldn't have been heard today. So in our respect submission, this entire application is, as I say, a distraction, highly unlikely to impact the procedural timetable. And in order to bring matters, to put some order on matters fairly, proportionately and expeditiously in accordance with the overriding objective, we ask that it simply be allowed to take its course. And if the court is happy that the 16th of December 2020 under the rules is an appropriate response time, and that the 30th of December 2020 is the appropriate reply time, then the only matter that the court might wish to consider is whether it should direct the date of the hearing of the immediate judgment application already, to identify that now. But I say that only as a suggestion, and it's not my submission, because of course the immediate judgment application is not really before you today. It hasn't even been before you. And therefore the court may wish to have the benefit of looking at that and again, and in its own time, making directions for the appropriate date of the hearing, rather than making it part of these directions. Those are my submissions, Judge, on that issue.
Thank you. Mr. Mashoud, do you want to say something?
Yes, Your Honor, I'm very grateful for this opportunity. Number one, my learned friend has made a broad brush point that the application in question, and I use my learned friend's words, patently heavy application. I regret to observe that not even one reason was given by my learned friend to support this assertion that it's a patently heavy application. Let me explain that it's quite the opposite, and it's on this basis. The only basis for the application for strikeout and summary judgment is twofold. One, and that's a first-year law student point. The defendant's defense is that the first defendant was entitled to terminate the contract in question because of a default by one of the shareholders of the claimant company. Now, every first-year law student even knows that a company cannot be made liable for default of its shareholders, even if it's one person who owns 100% shareholder of the holding of the company. So we say that the defendant's defense has no prospects of success whatsoever. On that basis, that is a simple point that we are pleading. And the second basis is that the defendant has accepted in its defense that the first and the second defendants are, because of an administrative site, are in breach of the contract. So because of the admission and because of that simple, straightforward company law point, we made the application. That cannot be by any stretch of imagination a heavy application. It does not come up with extraneous documents. It does not come up with a plethora of authorities, none whatsoever. So I respectfully yet forcefully disagree with my learned friend that it's a patently heavy application. We say that this point is simply being used to outmaneuver the force of our application and just to keep the indefensible defense alive for as long as possible, and that would be an abuse of court process, hence the application. Second point made by my learned friend was that it's a very late distraction. I regret to say that that is completely against the reality. As I submitted earlier on, strikeout application needs to be filed at 3 days notice. Immediate judgment application needs to be filed at 7 days notice. We gave 12 days notice. We served our skeleton arguments in full 12 days in advance. So that would have been that was the ample time given by us. The third point made by my learned friend, which I would say that was made just in quite passionate terms, yet without any substance, that those instructing me have shown lack of respect for every court order or direction, if I heard that correctly. I submit nothing has been brought on record. There has been no disregard to any order or any procedure or any of the RDCs by those instructing me. Even if there was any, that would have been nothing more than trivial. So we submit that the best course and the appropriate course of action in this particular case is, as I've said earlier, for the summary judgment / strikeout application to be heard as quickly as possible, because we say it cannot take more than a maximum of 90 minutes. Patently heavy applications are those, they go well over 2 hours. That's not the case here. So we say that immediately the application should be listed for a hearing, perhaps, ideally within 2 weeks, and that completely depends on the listing of the IFC courts. Once that application is heard, decided upon, that would be the best time for this court to narrow down the issues, give appropriate directions. That truly would be in the overriding interest. Regarding Part 24, sorry, the consolidation point, just quickly I would like to say that those proceedings are at present pending before the Court of Appeal, wherein the hearing is listed on 18th of January. So we say that until the Court of Appeal gives judgment on that particular appeal, I'm quite content to leave that consolidation matter until the Court of Appeal returns to us. So that second point, I'm not pressing much on that, but certainly the first point of strikeout/immediate judgment is my flagship point, unless I can give any further assistance to Your Honor.
No, thank you. I've heard enough in relation to this matter. If the parties do not want to discuss further this application, we can move forward to the dates. And after the hearing is over, I can give direction in relation to what was discussed today. So do you want us to look at the agreed CMC order?
Your Honor, yes, that is at page number 83.
Okay.
And in fact, if you look at page number 84, right at the top of the page, as paragraph number 1, that's where the standard production of documents. It's been proposed that that can take place by no later than 17th of December 2020.
Okay.
Well, in fact, I'm reluctant to read every single paragraph because certainly Your Honor can read that, so I shall leave that in Your Honor's hands.
I've reviewed the order. If parties are happy or it is fully agreed, then I have no further issues in relation to this order.
Thank you. Judge, might I just point to what I believe are just a couple of minor typographical corrections.
Okay.
The first is under the order for justice by reconciliation.
Yes.
There's a number missing. But then I think it should say both parties, so take out the words do not. Both parties agree that a stay of proceedings for reconciliation is not appropriate. So
Okay.
take out do not and put in the word not before appropriate. I think that might be uncontentious.
Okay.
Sorry, going back to paragraph 2, the date 2020 has a typographical correction. Should be 2021.
Mm-hmm.
Then there at point 9, the expert reports.
Mm-hmm.
I believe that this is now agreed, although it's not quite clear from the communications between the parties. But certainly it is our position that no experts are required in this matter. And there just seems to be in the manner in which this was put before you, there seems to have, it doesn't make sense at the moment. It says the parties agree that expert reports
I agree.
that are appropriate. It's our position that it should be not appropriate
Mm-hmm.
or not necessary. And I believe that is everything. On the following page, we have made provision for a chronology and the date, the estimated duration appears to be agreed at 2 days for the trial itself, May 2021.
Okay, so even the trial date is 21 December 2021.
Yes, indeed.
No.
Oh, sorry. Sorry, that's correct. It's their availability.
Yes, their availability. Yeah. Okay.
Yes, that is correct. Excuse me. Yeah.
Okay. Okay. Just send us the updated version, and the court registry is going to look at it. Okay.
Thank you very much.
If no one has any issues to discuss, we can conclude the session.
Your Honor, just my point on the preliminary point. Would the court indicate its
Yes.
observation on that?
Yes. Yes. You will receive an email by close of business today in relation to how the court is going to proceed in relation to the application and in relation to the CMC order.
Grateful, Your Honor. Thank you.
Okay. Thank you both for your time. Thank you.
Thank you. Thank you very much.
Thank you. Goodbye.
Goodbye.